has advised that he is trying to connect.
Good afternoon, Judge.
Good afternoon. How are you today?
Good, and you?
I'm well, thank you. I'm going to go virtually off the bench here for a moment. Again, Mr. Gormley has advised that he is trying to connect. He's having some issues with Spectrum. Mr. DePass, are you here?
Yes, Your Honor.
Okay, Mr. Goodman, Mr. Gormley communicated with the court and said he was trying to get on. It's now 3:10. I don't inherently need him for this hearing, so I'm going to begin. And I'm going to begin with notification of the following. This hearing is being conducted over the Zoom platform. It is therefore a formal proceeding of the 95th District Court being conducted fully in accordance with the statutes and the Constitution of the state of Texas. That includes giving the public access to this proceeding. We are giving the public access by way of broadcasting this proceeding today over the court's YouTube channel. It is currently being broadcast live on YouTube. Because it is being broadcast live on YouTube, it is conceivable that someone with more technical expertise than I could grab a copy of the video file, either off of Zoom or off of YouTube, and create their own record of this case. Because no order has been issued authorizing recording of this proceeding, I'm advising the parties and the public that this proceeding cannot be recorded, and that includes recording through the back door by way of downloading and preserving the YouTube video file or the Zoom video file. There's one record and one record only that comes out of this proceeding, and that is the record maintained by the official court reporter for the 95th District Court, Ms. Rouse, who will report this proceeding. Are there any questions about that?
No, Your Honor.
No, Your Honor.
Can I have introductions of counsel, starting with plaintiff?
Greg
Yes.
Gutman.
And Mr. DePass?
Yes, Aaron DePass, Your Honor.
Welcome both of you to the 95th District Court. Mr. Gutman, it is your motion. I'm going to state some introduction before you present your motion. And it's this. I honestly don't care whether you have a receiver or not. I don't care who your receiver is. The receiver is appointed by this court at your motion in order to help you collect the judgment that you are entitled to collect. I do think that the tenor of your multiple motions suggests that there's a reason why you keep struggling to get a receiver, but I'm going to leave that one alone. That's between you and the receiver. On the other hand, isn't this matter already up on appeal in the Court of Appeals for the 5th District of Texas?
No, let me clarify that, Judge. I'm glad you asked me that question because coming into hearings, I don't know what you do know or don't know by way of background or reviewing the pleadings. So if I may just have roughly 2 minutes and I'll summarize everything. Judge,
before you do, I don't need the whole summary. Honestly, I really don't. What I need to know is why, and I've read your brief in the 5th Court of Appeals. Why is this matter not already up on appeal, in which you have filed a brief in which anyone who wishes to respond has a deadline of
the 25th of November, Judge.
It's actually, oh yeah, it was the 25th of November. So whether or not a reply brief was filed, I haven't seen it, but not that I would care, because honestly, I don't. It's not a matter that matters to me. But this matter is before the 5th Court of Appeals right now, it appears to me. Tell me why it is not.
This matter is not. And here's the reason why. On July the 29th, Judge O'Neill signed an order. And that order set aside the turnover, as you well know, but then reappointed Mr. Gormley as receiver for the sole purpose of liquidating a single specific identified asset, a 1995 Jaguar, which has been waiting to be liquidated since June of last year. And Mr. Gormley became a substitute trustee at the end of June last year. He has never liquidated a single item of property, nor tried to in the entire time that he was receiver. I finally got fed up with it, and it's too much of a long story, but I finally filed my motion, and Mr. Gormley responded with his motion to set aside the return over. I don't want to go into that history. You're right, it's before the Court of Appeals. But when Judge O'Neill signed the order on July 29th, he specifically, in the order setting aside the turnover, reappointed Mr. Gormley as receiver for the sole purpose of liquidating this asset. Several days later, I forget if it's the 3rd or 4th of August, Judge Wheelers signed the precise same order. We have two orders setting aside the turnover and reappointing Mr. Gormley as receiver for the sole purpose of liquidating this 1995 Jaguar. Consistent with his best practice, he has never done anything to liquidate anything, including this particular property, which is readily available to him. I don't know. I haven't talked much with Mr. DePass about it, but I'm sure he has made it available to Mr. Gormley. So there's no question about it being an exempt property. Mr. Gormley considers it non-exempt property, and consistent with his practice since he was appointed nearly a year and a half ago, he has refused to do this. Now, the 1995 Jaguar is not a very expensive, valuable automobile, but I really need to get Mr. Gormley out of this case. All he has done is play the guy who puts sand into the machinery. He has done nothing constructive, but everything to destroy my ability to collect my judgment. Okay, and I'm hoping that the Court of Appeals reverses the decisions that have been made, and there will be a new turnover and hopefully a new receiver. But at this point in time, Mr. Gormley is accomplishing nothing except playing games. So I don't see the purpose for him to be there. And if he's out of the question, I can go to out of the way. I can go to the constable or sheriff, and I can get a order of execution, and I can have the car picked up and sold. But with Mr. Gormley there, it'll never happen. So that's why we're here.
Sitting here looking at Justice O'Neill's order. He ordered that the receiver attach only the one item of property the receiver found and reported to be non-exempt, liquidate the property as appropriate, retain 25% of the proceeds, and provide the remaining 75% to Mr. Gutman as the payment towards his damages claim. Why should I remove him from that?
Because he hasn't done what Ms. Judge O'Neill ordered.
Mr. DePass, do you have any comment on this at all?
No, Your Honor, I don't.
Your Honor, may I say something?
Sure.
A minute before you came on the bench, the court reporter advised me that there was a written response from Mr. Gormley. Just for the record, I have never been served with that response, and this is typical of the way Mr. Gormley operates. I asked that the
Okay. All
court.
right. I don't need to hear any more about Mr. Gormley, except about whether or not he should be removed or not.
I just asked that the court not give this any value because I've not been served with it. It hasn't been presented to the court.
For the record, I don't have before me a response filed by Mr. Gormley.
I did receive a response, Your Honor,
You did?
I did.
Did or did not? I didn't.
I did, Your Honor. I
Oh,
did
okay.
receive a response from Mr. Gormley.
No, that's somebody else.
It's not. Yeah. Okay. Mr. Gutman, I'm going to take this under advisement. I'm going to actually, because I haven't seen the response, I'm going to at least consider it. Nothing's going to happen between now and Monday that this will affect in any way. So I'm inclined to grant your request, but I'm going to see what Mr. Gormley has to say before I sign an order to that effect. Oh.
Your Honor, I would like actually just some clarification though. So with respect to this matter being up on appeal, that does not stay any further action regarding the property. Just for my own edification.
I can't see why that appeal would stay a thing. Number
Okay.
one, appeals don't stay execution generally anyways. As a general rule, you got to have a supersedious, something in supersedious, whether it's cash or a bond to supersede, even if you're appealing the entire judgment. And this judgment's not appealed. He's appealing a prior order involving the prior orders of the Justice O'Neill and Judge Wheelis. So,
Okay.
I mean,
Yeah,
if you're asking for your own clarification, I'm not sure what, but to me, that's almost black letter law. Unless you've got something that you're skirting around on that. So, Mr. Gutman, I'll be inclined to grant the motion, but I'm going to read Mr. I was just provided by the reporter. I was provided the e-filing link, but I'm not going to take the time to read it right now. Or I should say the e-filing receipt showing that he filed a document at 2:53 this afternoon. So,
all right.
Thank you, Judge.
Give me a minute. We got 6 minutes till the next hearing is on, and it's one that has to be ruled on today. Somebody waited till the very last day of plenary power
Oh, gotcha. Judge, this question may be out of turn. I'm not sure, but while we are waiting the decision of the Court of Appeals, would you have any objection to reconsidering a new turnover motion?
I'll consider anything you present. I'm not exactly sure why you're appealing, but fair enough. If you don't, if you're not appealing the appointment of Mr. Gormley,
No, I'm not. I'm
which is how I interpreted your brief, but then more I think about it, you got
Judge.
more error in here than I can imagine on a simple order, but fair enough.
Well, Judge, maybe if I may have a moment to clarify, the only thing, I'm objecting to only two things. I'm not objecting to the turnover order. I'm objecting to the order setting it aside.
As being void, because
Exactly.
it expressly authorized exempt assets to be attached. I understand.
We're going to make some law on this point, Judge, I think.
All right, if you fair enough. I have no dog in that hunt.
Okay. Well, I'm just going to wait until the decision of the Court of Appeals. I'll probably be back to request the appointment of an alternative receiver. So
All right.
that's assuming I prevail, obviously.
Very good. All right. You'll have an order by Monday.
Thank you very much. Do you want
Thank you.
Should I submit an order, or are you going to draft your own?
Well, actually, I would prefer you. I was actually going to look to see if you had uploaded an order.
I did not, and I apologize. Judge,
Then-
I'm going to upload assuming you rule for me, it's going to be an extremely simple order, like one-liner.
Very good.
So it'll be simple.
That would be very appreciated.
Thank you very much.
You're welcome. Thank
So,
you.
Your Honor, you're going to just review what Mr. Gormley submitted and then issue your order. Is that?
That is correct.
Okay. All right. All right. Thank you.
You are most welcome. But I believe I'm going to see you again one day next week. I think it's Wednesday or Thursday. There's where your client's the target of emotion. So.
Your Honor, if we have another minute, perhaps we can resolve that motion right now.
You can resolve it with Mr. DePass all you want. I can't consider it because there isn't notice of hearing on that today.
Okay.
All right.
Thank you, Judge.
Very good.
All right. Thank you,
Y'all
Your Honor.
have a great weekend. You're excused.
Okay. All right. Thank you.
Right. Do you want me to wait a moment, Judge, to let him in?
You can let him in at any time.
Okay, yes. Hello.
Hi. Good afternoon.
Good afternoon.
How are
Yes.
you?
I'm good. Can I get your last name again, ma'am?
Absolutely. It's Gravel. G as in George. R-E-V as in Victor. E-L.
Thank you. Maybe one of these days I'll remember.
Oh, I'm sure you will.
Good afternoon, council.
Good afternoon, Judge. How are you?
How are you?
Doing
I'm
well.
fine.
Very good. Before we begin real briefly, Ms. Rouse, are you ready?
Yes, sir, I'm ready.
All right. This is DC 20-02066. Council, this proceeding is being conducted over Zoom, obviously. It is also being broadcast on our court's YouTube channel. It is a formal proceeding of the 95th District Court. But in order to create public access to this proceeding in accordance with the open courts provisions of the Texas Constitution, we are choosing to broadcast this over the court's YouTube channel. I'm not in the courtroom. The virtual background may suggest otherwise, but I'm actually also remote today also. So the courtroom door is closed, so the public doesn't have access by walking into the courtroom. So that is why we are choosing to broadcast over YouTube. However, I have to advise the parties and the public that you cannot download and save the YouTube video file or the Zoom video file in order to create a record of this proceeding. There is one record and one record only that comes out of proceedings in the 95th District Court, and that is the record maintained by the official court reporter of the 95th, Ms. Rouse, who is here and who will report this proceeding. Now, let me get introductions of counsel, starting with Ms. Gravel for plaintiff.
Good afternoon, Your Honor. Beatrice Gravel for the plaintiff.
And Ms. Dockery for the defendant.
Yes, Your Honor.
Please introduce yourself.
Yes, Christy Dockery, attorney for the defendant.
Very good. Welcome both of you to the 95th District Court on a Friday late afternoon. And let me tell you, I'm not sure the defendant has thought this through very well. This is a motion for new trial, correct?
Yes.
All right. Number one, that motion for new trial has already been overruled by operation of law 30 days ago today, by my count.
Yes.
So if y'all want to go with me on the timeline, I want to make sure that the dates are calculated correctly.
That's
Judgment
correct.
was issued on the 21st of August, correct?
Yes.
Yes. And the 30th day would have been that Sunday, Your Honor. But because of Texas Rules of Civil Procedure section 4, because it fell on a Sunday, it would therefore the last day to be able to file would be the 21st of September, which is the day that.
Correct, and it was timely filed. So it was filed on the 21st, which is the 31st day, but because the 30th day was a Sunday, it was timely filed. That would mean, if my math is correct, day 75 after the judgment was November the 4th. Am I correct on that?
I agree with the court. I was calculating the days as well, and I have nothing to add.
Let me check. The 75th day being December 5th.
Are you sure about that? Because I'm willing to reconsider my math, but day 30 would be September 20. Day 60 would be October 20. Day 75 would be 15 days after October 20, which would be November the 4th. Am I off somehow on that?
I have December 5th because we counted from this. I counted from September 21st because September 21st would be the proper day because that was the day under Texas Rules of Civil Procedure. that would be the final date, because September 20th fell on a Sunday. And because it fell on a Sunday, it would be the next day that doesn't fall on a Saturday, Sunday, or holiday under Texas Rules of Civil Procedure.
Now, I'm
No.
intrigued by, I don't think you're counting to the right day 75. Ms. Dockery, isn't it day 75 after the judgment?
Yes.
1 second.
Under this may not be fatal, but we got to make sure we're doing this correct.
Your Honor, I don't know if you want me to interject
I'm
or
I'll-
not,
I'll-
but I'm looking,
Yes, you may.
obviously, I'm looking at Rule 329B as the court, just cited, and it definitely says that we have 75 days after the judgment was signed, as Your Honor said.
Specifically, you are referring to Rule 329, little b,
C,
open parentheses, little c, close parentheses, correct?
yes, I am. And it says, is not determined by written order signed within 75 days after the judgment was signed.
Ms. Dockery, do you agree that that is the proper calculation?
Um, oh. Yeah, it would be 75 days from the judgment day. But I would add that there is a Texas Supreme Court emergency order in place. That's what I'm trying to look up right now.
It hadn't extended the appellate deadlines in any respect, just for what it's worth. I've read the emergency orders. All right. I'm confident that calculation is correct. Therefore, this motion for new trial was overruled by operation of law on day 75 after judgment, which is November the 4th. So I can't consider the motion for new trial. However, I have plenary power over the judgment for 30 days after the last motion attacking the judgment was overruled, which means it was overruled on November the 4th. So I have until midnight tonight that I have power over this case to do something with the judgment, should I be convinced to do so. Well, Ms. Gravel,
Yes.
what is plaintiff's position on granting a new trial? Forget that. I'm not talking about the timeliness or what is your position about a new trial?
My position and the plaintiff's position is that the motion should be denied. In addition to what we just went through, as far as the timeline is concerned, as you know, there are the Craddock factors, and they were certainly addressed in the motion for new trial. And the defendant was stating that they need to engage in discovery to perhaps find a reason. So that is not a Craddock factor. It has to be explicitly stated in the motion what the problem is, and it isn't. And in addition to that, we have submitted with our motion for default judgment evidence which showed that the motion was filed correctly and was meritorious.
Ms. Dockery, I have to agree with Ms. Gravel that the Craddock factors. I thought that was it was Mr. Weston who signed the affidavit, right?
Mr. Heston, yes, Your
Mr.
Honor.
Heston, yeah.
It's okay to address the court on those factors. I can go into more detail.
I'll listen. Convince me that I should not. You've got to convince me that I should grant a new trial now, because your motion for new trial has already been overruled by operation of law. So convince me to use my plenary power to overrule the judgment that's now been final for 105 days.
Yes, Your Honor. So according to their default motion, there's several things that are incorrect in the motion. They make reference to a terms of agreement for an account number ending in 81008, but do not provide any statements or any proof of that account. In fact, they provide statements for an account ending in 82006. There's no statements that show that those two accounts are the same or making reference to that. There is no testimony from anyone at the motion for new trial hearing. It was proved up by a business record affidavit. That business record affidavit is conclusionary and is hearsay because they have not provided any proof within that business record affidavit that shows that that account is what's referenced. Again, the terms of the agreement that's required under the law, the finance code and under federal rules, requires that the terms of agreement is what lists all of the interest rates and whatnot, so that the damages could be properly calculated. However, it makes reference to an account ending in 81008, but statements that were included make reference to an account of 82006. Therefore, a plaintiff has not provided any proof of how they properly calculated their damages in order to succeed under that breach of contract and account stated. They have to actually present evidence to show how that account was properly calculated to show them the amount that was supposed to be due under the default judgment, and they failed to do so.
Ms. Gravel?
Yes, Your Honor. First of all, if there was any question about it, they could have addressed this, timely. I am right now trying to find the actual affidavit, which the difference in the last 3 digits is usually very easily explained because an account number changes. For example, if the card member requests another card, the number will change. And the affidavit does state whatever it is formally ending in. So unfortunately, I don't have it in my hands, but I am trying to get to the affidavit right now.
And Your Honor, I would object to plaintiff's counsel testifying to the case as she would not be a proper witness to provide.
All right,
I wasn't testifying.
The
I was
record
simply
is,
trying to explain.
she isn't testifying. The record is what it is. I'm sitting here, Ms. Dockery, and I want you to convince me that I should exercise plenary power to set aside a default judgment which was properly moved for, received, and your motion for new trial has already been overruled. And convince me of that. Convince me of manifest unfairness of this proceeding or something to convince me that I should set aside something that has been final now for 105 days.
Well, yes, Your Honor. So first, we did timely file our motion for new trial. It was not heard until today. Yes, and that could be an array of different factors contributing, one being COVID. Our next issue is under the Craddock factors, one of those elements is a meticulous defense, and we do have a defense. They have not properly provided evidence that shows that of proper calculation of damages under their breach of contract claim. They have to provide evidence that shows that their damages, the amount that they owe for damages, is properly calculated. All they did was provide a statement that statements that are associated with the account that's not associated with a terms of agreement that lays out how interest rates and whatnot are calculated for that credit card. Without proper information on how that's calculated, and I can provide that case law to you, Your Honor, there's a lot of case law that has been overturned by the Court of Appeals here in Texas, by several courts of appeals throughout Texas, that shows when it is not properly provided to the court on how those damages are calculated, then they cannot prove their damages aspect of their breach of contract and account stated. One of those examples of that, and I can bring that up, Your Honor.
Ms. Dockery,
Yes.
I'm not trying to. I'm afraid. Have you frozen? Oh, I'm afraid you have missed my point. All right. I mean, I'm really. All right. I don't think the motion for new trial laid out the Craddock factors correctly, for starters. But I normally would grant a motion for new trial in a heartbeat. Under such a circumstance, because frankly, I have not denied a single motion for new trial since I've been on the bench when a motion for new trial was properly presented. And this one was filed and was overruled already by law because your firm did not seek a hearing on it until after it was already overruled by operation of law. And I want you to tell me why. No, don't tell me this, because frankly, the 006, 008 is, and I fair enough, I understand that's, you want to stick your hat on that, but that is explained by Mr. Rebhams, that's R-E-B-H-A-M,
Yes.
by his affidavit.
And I have it up as well, Your Honor. I found it in the meantime.
Ms. Gravel, I really don't need to hear. I mean,
Okay.
I've read all this.
Yes.
And I read it before I granted the default judgment. Why? Show me why I should use the court's plenary power to grant a new trial when one has already been overruled by operation of law.
Yes, Your Honor. It was through. So one of the factors, I know that you're not a big fan of the Craddock, but one of those major factors.
You know, I'm not what?
I'm a big fan of our argument of the Craddock factors.
It's not an issue of that at this point. That's what I'm trying to explain to you.
So
your motion for new trial has already been overruled. So tell me why I should grant a new trial.
yes, Your Honor. So we're here today. It was not through mistake or whatnot. Our client, like we stated in the original motion, our client did not know of him having to file the answer. We properly filed our motion. It was not our intent to purposely delay or cause harm or whatnot. We hear hundreds, if not thousands of cases against the plaintiff in several of the courts throughout Texas. We have worked with plaintiffs several times. We have handled these type of cases on a regular basis with them. This is not to cause delay or prejudice. If anything, this would cause harm to our client because our client would not be able to get a fair share in court. This will not cause a delay, Your Honor. The parties can go ahead and work out settlement and work through what we need to. If discovery is needed. We have documents that have already been provided with the court. This is not for delay. We can also ask the court, if the court does grant the motion for new trial, that it immediately set it for trial so the parties can try to work out this case. We're not trying to cause any delay.
Have you attempted to settle this case with American Express in the 105 days since the default judgment was granted?
I would have to look at the file, Your Honor, because and to see
please do, because that's what I was wanting to hear. I want to hear that y'all have been trying, and because I know, please know this, Ms. Dockery. I have. Are you with the Heston firm, or are you appearance counsel?
I'm an employee with the Heston firm.
All right. I have operated as appearance counsel in this arena when I was in private practice for years. I know that American Express and the Heston firm inevitably settle everything together. I've observed that. Very few of their cases, a percentage, but very few of them don't go to or end up going to actual trial for a variety of reasons. I'm aware of that. But I'm also aware that this thing has sat for 105 days since judgment, and you came to me on the very last day I had plenary power after the motion for new trial is overruled, and I want to know what you've done to try to resolve this and get rid of this issue entirely.
I would have to look at the file, because although I am an employee with the firm, this is not my particular case. I'm covering for an attorney that is out sick. But I can definitely let you know, Your Honor. We, like you said, we work with plaintiffs' counsel on a regular basis. We have hundreds of cases open with them now, today. So this is not something that we're going to cause the delay. I do think that we can come to a settlement agreement. And like I said, if you do grant this, I would be open to having this case immediately set for trial and for the parties to start working immediately to get this settled. But this is not to cause any delay, Your Honor. It's to just to be able to give our client a fair chance at getting this case settled and worked out without having to deal with the court's time. And usually, as you know, Your Honor, with these cases, they end up being through a settlement agreement with an agreed judgment as well. So it's not as if plaintiff's counsel will have any harm for granting this delay, because at the end of the day, they'll get their judgment.
Ms. Gravel, if I were to grant a new trial, how quickly could plaintiff get a motion for summary judgment on file? Because I know that's going to be your next move if I grant a new trial. How quickly can you get that motion on file?
I could do it next week, but Your Honor, I would like to ask again that the motion be denied. If Ms. Dockery feels so strongly about settling this case, she can call me at any time except tomorrow and on Sunday.
All right, fair enough.
And I will work with her. And the default judgment is by no means prejudicing, her client or her communications with me. It doesn't mean we couldn't settle just because we have a judgment.
But with the default judgment and then you no longer having the plenary power, it allows plaintiff to start doing enforcement and garnishment proceedings, which in the end could cost the client more money, because then now we're thinking of receivers and whatnot. With us just settling, we don't have to worry about getting the court involved, receivership, garnishments and whatnot. We can just get
you can settle post judgment just as readily as you can settle pre-judgment. In fact, sometimes it makes it easier because the amount is absolutely set. I don't recall whether or not they waived post-judgment interest on this or not without looking at it, but
as I said, Your Honor, if Ms. Dockery wants to negotiate with me, I'll be here commencing Monday morning. And I do not believe there will be post-judgment interest assessments.
And Your Honor, like I said, as soon with you losing the power to be able to preside over this case, they can immediately go into garnishment proceedings, and it'll just cost our clients more money in the end because of receivership costs and additional attorney's fees that we may have to occur, as opposed to just having our client just go ahead and try to work out and settle this. And
Your Honor, we will have a difficult
I mean-
time garnishing somebody's wages in Texas.
Let me ask this, and then I'll tell you what I'm gonna do. Seriously, why did he not answer on time? This was, from what I understood from the affidavit or the declaration, this was not his first rodeo of being sued. Why did he not timely file?
so I believe that he has several cases, and one of them, I believe, is with counsel. And my understanding is that when we talked to our our client, he was under the impression that this was for the same case, that they were refiling for the same case that he already has. And once he received the default judgment from the court, he notified us, we researched it, and that's when we found out, no, this is for a different case. So we didn't even have knowledge of it until he presented to us. That's why the day that we found out is the day that we filed our motion.
So he waited till 30 days after the judgment to even contact you.
No, he actually contacted us over the weekend, and we filed it Monday.
All right. Like I said, he waited until, fair enough. I'm not convinced that if this were day 75, I'd grant a new trial just because I grant new trials. But it's already been overruled by operation of law. I'm not going to use my plenary power. If you wish to appeal it, today is the appeal deadline, but then there's the provision for the extra 15 days. And you can go that way, but I suggest calling Ms. Gravel on Monday might be the better part of valor anyways. So I'm simply not going to do anything, which means, because I can't overrule the motion for new trial, it's already been overruled. And I'm just not going to extend my plenary power to overrule what's already been overruled.
Okay.
All right.
Yes.
All right. Anything further?
No.
No,
Thank
Your
you, Your Honor.
All right. Y'all have a good day and a good weekend.
Honor.
Thank you.
And
You as
continue
well.
to settle your cases together. And I mean that seriously. So, because it's in fact, it's odd. I've got both counsel actually work for the firms. I don't have appearance counsel on either side here. So y'all work this out. In fact, call each other right now and resolve this. Well,
I
but
don't see a problem.
all right.
Thank you.
Thank you. All right. And Ms. Rouse, we are in recess